Good morning, everyone. Welcome to Senate Judiciary, those joining us online and those in the room. Good morning. We have a couple of bills for consideration this morning. The first one, Senate File 181, sponsored by somebody we know pretty well, Senator Schuler. And Senator, I'm going to jump right into this. I'd love to get both of these bills considered this morning and hopefully get them upstairs. So Senator Schuler, take it away. Tell us about Senate File 181.
Thank you, Mr. Chairman. Committee, I bring you this bill. This is Senate File 181, drug-induced homicide. And actually, this issue came to me from our county attorney and some of the folks that are working with the DCI, some of the drug task force folks. We have some issues, obviously, on our side of the state. We're a border town. We're on I-80. We have a lot of various types of drugs that are coming across our border, and they're seeing more and more deaths and issues, some serious issues, especially with fentanyl, but also with meth and heroin. So what we're doing with this bill basically is we're just amending the drug-induced homicide statute 62108 and renumbering just a little bit of it. And it's pretty simple. It may have some serious complications or complexities later on, but we think it's something that might actually help to stifle some of the drug traffic and possibly save some lives. That's really the bottom line with this drug. So if you want to take a look at the bill on page 1, there really isn't much change there other than A stays the same. A drug-induced homicide, the penalties, A person's guilty of a drug-induced homicide. We just renumbered I to he. And then over on page 2, that part stays the same, but it's just moved down a little bit. They still have to be an adult. They still have to be at least 4 years older than their victim. And then B really just takes the place of what used to be I. This is a violation of Wyoming statute 357103(1)A I, or 2 or BI, or Romanet 2. All of those are just different types of controlled substances is what those are. And so that part really stays the same. So the part that you're probably most interested is on page 2, line 12. This is the part that we've amended or added. And what it says basically is that we violate this statute 357103(1) I by unlawfully delivering fentanyl, heroin, or methamphetamine to another person, and that person dies as a result of the injection, inhalation, ingestion, or administration by any other means of any amount of the fentanyl, heroin, or methamphetamine. It's not a huge addition, but it has, like I said, a lot of, I think, implications, and it's something that at least in our corner of the state, the folks that are working with the drug task force over there and our county attorney who has to prosecute or see some of the issues that happen as a result of, especially, like I said, we're seeing more and more with the fentanyl, but also we still have some issues with meth and heroin. These are the big 3. So we didn't add any of the other controlled substances that are in 35-71031, but other than those 3, those are the 3 we want to focus on. Those are the 3 we want to try to put a stopgap in and just at least maybe have people feel like, if you're going to bring these drugs into our state, and whether it's a minor, an adult, doesn't really matter if they die as a result of your delivery of these or, getting those to someone, you're going to have to deal with a homicide. That's pretty much the bill in a nutshell. I'd be happy to stand for questions.
Okay, thank you, Senator, for bringing this policy consideration. Questions, committee? Senator Case.
I feel like Charlie Scott all of a sudden. Mr. Chairman, Senator Schuler, I don't know if this is the entirety of the law, but I'm trying to see what the standard. There's not a willful or knowingly kind of standard. It's just if you're delivering something illegal and the person dies, So it can't be like you were careless in the preparation or anything like that. You were, so it's any amount, any time. And I guess it would also apply to like a third party. So like, say I intended to deliver a controlled substance to the chairman, but it was intercepted by Senator Furphy, and Senator Furphy, maybe he's a child, and so that would also apply, I would assume.
Senator, can you help us with
Yes,
that?
thank you, Mr. Chairman. They wanted it to be pretty black and white, and I get that. I think, there's other statutes in there that talk about criminally negligent homicide, but they really wanted to go for the drug-induced homicide, and even though there is a statute in there for minors, this one basically will take care of the adults. We're seeing more with the adults than we are the minors, but issues. But no, it really, I think if they can trace it back, that's going to be the big issue, I think, with our law enforcement people, is whether or not they can trace the drug back to the original dealer. And apparently they seem to think they can in some of these situations. And I think that's the hope, is that they can, and then hopefully they can, deal with the issues after that. But they did not mention anything about a third party. This really doesn't take a third party into consideration. So good question, though.
And Mr. Chairman, just
Go ahead, Senator Case.
I mean, I've definitely heard of this problem where this is horrific. All this stuff is horrific, but like fentanyl is very deadly, very powerful. And it's used to cut other drugs, and so you don't know the dosage. So you could be buying from the same supplier forever, no problem. Then you buy from the same supplier, same appearance and everything, you believe, and you go to and you die. I get that. I mean, this is kind of a culture where even the suppliers are probably, at least at the street level, I bet they're addicts as well. I mean, it's a cesspool kind of deal. I'm not sure what the murder, for those people, I'm not sure what charging them with murder would achieve as far as deterrent, but maybe there's people upstream on the supply chain is who we're trying to get at. But for those, it seems that the ones that are, I better shut up. Thank you. I appreciate your thoughts.
Thank you, Senator. I think that really goes to what the bill is all about. So, Senator, I had a question. So you're county attorney. I'm sure this would make it a little easier to go after someone. I guess you could still go after someone. It's just that this allows you the greater charge. Is that correct? Can you help me with that? Remind me what we can do now?
Yes, Mr. Chairman, I think that's really the intent of the bill, because I think, as I mentioned before, if they charge somebody with criminally negligent homicide, they can actually only charge them with, I think, a year in jail and a fine of, I think it's $2,000. And I think that at least the folks over on my corner of the state felt like that we weren't, they were getting repeat offenders. And and this is where some of the, excuse me, some of the deaths and the near deaths were happening, as with, I think, some repeat folks that maybe didn't just get maybe they got a slap on the hand, or maybe they didn't. They wanted to really bring it home and to really put the hammer down. And I think originally when I talked with the attorney, that she had actually even wanted to bump it up to murder one and or murder two. And I didn't think that would fly. And I visited with some of the other lawyers in both the House and the Senate, and we kind of came down on the side of just manslaughter, and not that it's just manslaughter, but the fact that hopefully that's a big enough deterrent. You're taking the life of someone else because of your, I think, reckless behavior with drugs, particularly the fentanyl. I mean, we're seeing fentanyl-laced drugs as well. And, with the issues, they're so, I think even the law enforcement folks are pretty nervous about this right now with the fentanyl-laced drugs. obviously they're even more dangerous for them to even when they're doing drug busts, to come upon a certain amount of fentanyl versus, in the old days with meth, wasn't quite as big a personal health issue as the fentanyl is. But I think that this is kind of this message that the folks in law enforcement on my side of the state were wanting to send to those people that are dealing these three things. And like I said, we didn't include some of the other controlled substances. We didn't talk about opiates. We didn't talk about some of the others, but just those three. Those are the big three that they have the most problems with.
Thank you, Senator. Further questions? Senator Cooper.
Thank you, Mr. Chairman. So, Senator Schuler, it comes to mind that presentation we had when we started here, and the fellow up in the northwest part of the state that delivered, and the person he thought he was delivering, said he thought he was delivering, I don't remember, it was maybe oxycodone or something, but it turned out to be fentanyl, and the user died of it. And if I remember correctly, he was charged with delivery and child endangerment because his kids were around it. So this would give our prosecutors the ability to take that person and because he wasn't a user, he was just a dealer. So this is the guy type of guy that we're looking for with this also. Is that correct?
Go ahead,
Mr.
Senator.
Chairman, yeah, thank you. That's exactly, I think, the message that I think those folks are trying to get. It's I think in the past, some of these dealers, they don't think about the long-term consequences of whether it be a child or whether it be an adult, and we've had some issues with both. The statute already is in there for fentanyl with the child if a death occurs in the statute, but this just adds an adult. If an adult dies and a person that's at least 18 years old and they're at least 4 years older, they should know what's going on. They're an adult. They know that if they're dealing, it's a pretty serious thing. This is not like we're trying to get a hold of some marijuana or something that may be a little less harmful. These drugs that we mentioned here are drugs that will kill other people, and particularly the fentanyl. I mean, we could have just left it at fentanyl, not added the meth and the heroin, but that was their push to try and get the big three, anyone that's delivering those big three. And whether or not it'll be a deterrent, I hope it will be. I mean, that could be hard to say without getting maybe a little more data, but it definitely puts the hammer down, and it takes it to a different level than what was there before.
Sure.
Yeah, go ahead, Senator Cooper.
So this was brought to you by your county attorney?
Mr. Chairman, yes, county attorney, and then some of the DCI folks that were working with some of the drug task force.
Unfortunately, Senator, supply seems to find demand, doesn't it? But any other questions for the sponsor of the bill? Okay, I want to go to testimony. Is there anyone in the room this morning who wants to testify on Senate File 181? Would anyone like to testify on Senate File 181? Please come forward. Thank you for being here. If you would state your name for us, we're online this morning, and folks listening in from around Wyoming for sure. So please.
So I'm not really sure the answer to this, and actually I just kind of got stuck here in Cheyenne and came to the meetings and felt like this was supposed to be the one that I come to. But I will tell you my experience working with the Department of Corrections in the Casper Reentry Center in Casper, Wyoming for several years. So we worked in drug and alcohol treatment. I was on the TC program for about 5 years, and then I was on the Native American unit, the BIA unit, for 4 years. So my experience is that, you're always working with addicts, and you have those inmates that come and really want help in addictions. And then you have the flip side of that, where it's the criminal drug dealers and so on. So my experience on both sides is that I feel in the state we've got to have stronger laws against them, because there is a major difference, and you can talk to most therapists in in the field who say there's distinctly the addict and the criminal who just wants to make money, who may use occasionally, but then there's the drug addict. Unfortunately, what I saw on the Native American unit, the problem that we have all over the United States is that a lot of these drugs, and they're pretty open about it, Native Americans are, is that they're coming across the border and they get in the hands of the Native Americans who can jump from reservation to reservation and not get busted. That was my issue on the Native American unit, is that we were always dealing with BIA and then US Marshals who wanted to come and take them and give them a federal offense, and then BIA that came in. So you have those, that population that brings it in and distributes it to somebody else who's like kind of the middleman drug dealer, and then it gets out on the streets. But in my opinion, there does need to be harder stipulations on the drug dealers, because that's where the problem is. You do, people that really want to get help will get help, will bottom out or whatever. And even those guys will tell you, and women will tell you, sometimes behind bars does something well. And I'm not one that would push for behind bars, but I think there is a time and a place. I actually had a son that had to be incarcerated, and it's just comes with the territory. But I do think we need stronger laws, in particular on those that are dealing the drugs, because most of my experience with them, they know what they're doing. They know what's included in those drugs. Methamphetamine was, to hear the horror stories of what was put in methamphetamine knowingly, willingly, and some of these guys laughing about it, unfortunately, because the bottom line is the buck. And that's unfortunate I can't even tell you the list of things that some of these drugs are laced with intentionally just to make more money on it so they don't have to use, more methamphetamine or more fentanyl. It's horrendous what's put in there. And so, yeah, I think we need to have, that's my opinion.
Ms. Martin,
Yes.
we have not met, but thank you for being here this morning. I'm glad you made it down from Casper. We have a leadership group up there that's marooned and can't get here, and so
Oh, I was
appreciate
coming from Florida, so I just got
Oh, well,
stuck on the way back.
That's a much better way to come in from than up
Right,
north,
yeah.
I'll tell you. We
Yeah.
have some other visitors from up north who had a little bit of a trip getting here, so
Yeah.
we'll hear from them a little later. But questions for Ms. Martin? I appreciate your testimony. Thank you for that. Okay. Is there anyone else who would like to testify on 181? Judy, do we have anyone online this morning who wishes to testify on Senate File 181?
There's no one with their hand up online.
Okay, we're going to close testimony. Committee, what's your pleasure on this bill?
Bill.
Senator Cooper moved the bill. Discussion. Any discussion? Senator Furphy.
Thank you, Mr. Chairman. Based on that last testimony, I wanted to comment on what we heard a week or so ago from our department that investigates this. How much huge profits there are in fentanyl, and how we have got to stop this drug from expanding in our state. But that's my only comment, Mr. Chairman, about the huge profits that the drug dealers are making off of this drug. And I want to thank Senator Schuler for presenting this bill. We've got to stop that, especially in kids. Thank you, Mr. Chairman.
Senator Cooper. Then we'll come
Thank
back.
you, Mr. Chairman. I'd like to see the bill move on up to the floor for discussion. I've got some people in my district I'd like to talk to, some experts that give me some better advice. But I think it's well worth having a good solid debate on the merits of this, and I'd like to see the bill move forward.
Mr. Chairman. Senator Case.
So this isn't murder, this is drug-induced homicide. What's the penalty for drug-induced homicide? How does it fit in the murder statute.
Senator Schuler, can you help us
Yes,
with
I
that?
can. Yeah, it's actually, it can be anywhere from 10 to 30 years. So 10 is the minimum. And if you think about it, 10 years to the drug dealer for a life is really what you're trading. I mean, they could give them 30, but 10 is the minimum on that.
So maybe this has
Go ahead,
changed since I was
Senator
last on the committee, but we used to talk about first, second, third degree murder. So does it fit in with that criteria, or is it separate? It's okay if we don't know that.
Senator Schuler, can you help us on that front?
Actually, there's a lawyer in the room that might be able to tell you a little bit more, but I know that with first and second degree, I think the penalties are more harsh. I don't have them in front of me right now, but like I said, this drops it down to like manslaughter, in essence.
But it says homicide,
Yeah,
not manslaughter.
it does say homicide, but
Yeah.
that's where I see it fitting into the statute.
And so, Mr. Chairman, there's the manslaughter statute, and you got voluntary and involuntary manslaughter. But this says murder. It doesn't say anything about the person's intent or mens rea or whatever is behind that. It's just if the event happens. And it's like that story we heard of the death the other day. The sap dealer who came by maybe is a terrible human being, but he thought he was delivering stuff to get somebody high and serve their addiction. He wasn't, that person did not think they were going to kill somebody. And I understand we want to stomp that. We want to stop it. But I think our evidence in the drug war is that we're not stopping it with these penalties. So probably be a no vote. Thanks.
Senator Case, that's where I'm really wrestling with this. I'm inclined, as Senator Cooper is, to go ahead and move this forward. I think there may be some room, Senator Schuler, for some conversation about whether or not this is landing exactly in the right place. I question, just like the senator from Fremont County. I mean, higher penalties, do they help? I hope so. I just don't know. This I-80 corridor that you live on, Senator, is tough. It's really, really tough. And so further discussion. Senator Schuler, take us home on this
Yeah.
bill, would you? And we'll have a vote.
Yeah, Mr. Chairman and the committee, the other thing I would just point out is that if you look on page 2, this is already in the drug-induced homicide statute, where if they violate those same drugs and deliver those to a minor and that minor dies, that's already in the statute. So all we're doing really in essence is we're adding just 3 of those drugs and making it pertain to adults. So I know it's a big step, and I know it has certainly some ramifications, but again, I think it's something that we need to try and stem the tide.
Okay, thank you, Senator Schuler. Judy, would you take roll on Senate File 181, please?
Senator Case,
No.
Senator Cooper,
Aye.
Senator Furphy,
Aye.
Senator Schuler,
Aye.
Chairman Landon.
Aye.
Mr. Chairman, there are 4 ayes and 1 no on Senate File 181.
Okay, thank you, Judy. Senate File 181 has passed the Judiciary Committee and will go upstairs. And Senator Schuler, best wishes up on the floor. I think this is a good policy discussion to have. I look forward, there are a lot of good people in the Senate, and so I look forward to that policy discussion upstairs. Okay, let's move on to our next bill for consideration, committee. Senate File 161, Parental Rights Repealing Conflicting Statute, sponsored by another one of the good senators in this building, Senator Beitman. Senator, would you like to come forward and tell us all about Senate File 161 this morning? You're welcome to bring those constituents up, whom I met a little bit earlier. Come on forward, you guys, and You can sit right there by the sponsor of the bill. And we will come to you guys in just a little bit, okay? For now, we're going to go to the senator, and he's going to walk us through the bill that he has brought to us.
Well, good morning, committee, Mr. Chairman, Senator Beitman, representing Senate District 21. I bring to you today Senate File 161, Parental Rights Repealing Conflicting Statute. It's an act related to domestic relations, providing findings, repealing a statute authorizing the establishment of grandparents' visitation rights, and making conforming amendments.
Senator Beitman, can I ask you to get a little closer
You
to that
betcha.
microphone? We all
I
wanna-
tend to mumble, especially this
wanna
early in
hear
the
you
morning, Mr.
well,
Chairman.
and I know those back home do too, so.
So the reason for this bill, every now and again in the legislature, we find a couple of statutes that butt up against each other. They're diametrically opposed to each other and they conflict. And when we have conflicting statutes, we end up in the courts and our good citizens end up tied up in legal battles they probably shouldn't be tied up in because of maybe an oversight on our part as legislators. So back in 2017, when I used to serve on the Judiciary Committee down at the other end of the hall, we looked at the parental rights statute and really wanted to strengthen that and make sure that it was in accordance with the landmark Supreme Court case on parental rights, and that is a fundamental right. We did that. We did that back in 2017. What we overlooked was a statute that was still on the books in Title 20, which is Chapter 7, 101, which provides a cause of action for grandparents, gives them standing to sue to establish visitation rights. Well, it doesn't specify whether or not these parents are fit parents under our parental rights statute. It's kind of a blanket opening for them to do this. And as you will hear a testimony from my good neighbors, they got caught up in this. They're fit parents. Their life has changed in circumstances to the point where you'll hear that, it's just their decision to do what's best for their children kind of ran up against this statute, and they're caught up in a mess right now. So I could give you more background on the whole parental rights argument, but I might come back in and maybe fill in some holes after they tell their story, and it might generate some questions in your mind as to what we're after here, sir.
That sounds good, Senator. I think we've all read the bill, but if you want to dive
Sure.
into the bill real quickly.
Oh, yeah,
Just
absolutely.
point to exactly what's going on with the bill and.
Yes,
and then
sir.
we'll go on
Mr.
to
Chairman,
some testimony.
it's normally would be a one-page bill, but I did add some findings because I thought it was important to provide some findings for the courts in case this were to end up in court. Just specifically that the legislature finds, and like I said, on page 1 in 2017, we enacted the parental rights statute, which provides that the liberty of a parent to the care, custody, and control of a parent's child is a fundamental right residing first in the parent. And then before and after the enactment of the statute, the legislature has always intended to protect the fundamental right of fit parents. And that in recent years, courts have not consistently applied our parental rights statute and in conflict with the grandparent visitation statute. It's led to situations where the fundamental rights and decisions of parents have given way to visitation requests by grandparents. Also, it goes on to reaffirm that the parental rights statute provides that the state or any agency of the state shall not infringe a parent's fundamental right without first demonstrating that the governmental interest as applied to the parent is a compelling state interest addressed by the least restrictive means. And this act is intended to remove any ambiguity or conflict between the fundamental right of fit parents and the right of grandparents to have visitation over the objection of fit parents. And so then you go in the conforming language, Mr. Chairman, on the rest of page 3, you'll see I don't know if you have a color copy, but the blue statutory reference to the grandparent visitation statute is struck. Moving on to page 4, some more conforming language. Section 3 is the repealer, which is the whole bill, basically. the bill and the findings. Section 4 says, obviously, nothing in this act shall be construed to affect visitation rights granted to grandparents before the effective date of this act, which keeps it constitutional. And Section 5, it becomes immediately, as soon as possible, the effective date. And that is the bill, Mr. Chairman.
Okay, Senator, thank you. Questions, committee, of the sponsor of the bill? Any questions? Senator Purphy, and then we'll come to Senator Schuler.
Thank you, Mr. Chairman. Senator Brightman, my concern is lately this is a big issue. A lot of grandparents are taking over managing children because the parents were fit at one point, but circumstances change, such as alcohol, drug problems, etc. So my concern is on page 3, where it discusses the fundamental right of a fit parent. And so then that fit parent at that point refuses to have grandparents visit the children. And unless something develops, whereas the city or county has to step in and say, wait a minute, you're not taking care of your kids right. So my concern is there is an opportunity for grandparents to step in and say, wait, these parents are not taking care of the children. I just appreciate your comment on that, Senator.
Senator Brightman?
Mr. Chairman, Senator Furphy, that's a great question. There is a mechanism in place. That's why we used the language carefully about fit parents, because that can change, of course. Like you mentioned, drug and alcohol abuse is rampant in this state. We see, when I was on Judiciary, we saw a lot of really heartbreaking testimony to that end. And so it's a delicate balance. So it's very important that there's a process in place for grandparents and concerned people to have that avenue to bring those parents that may not be fit anymore into the court system and have that determination. What's happening though is fit parents are kind of getting their rights taken away, and that's why the need for the bill. But we also have to make sure that we, like you said, in the case of unfitness and drug and alcohol abuse, there's a way for grandparents to step in. And there is a mechanism for that. And I'm sure you'll hear about it from our agencies. Hopefully that answers your question.
Senator Schuler, did you have something?
I think Senator Furphy and I were on the same page. I really kind of focused on the fit part of it. What first came to mind was the idea that, let's just say a parent, maybe a single mom, gets involved in drugs or alcohol, gets the kids taken away, grandparents have them, maybe they go into drug rehab, they come out. How does the court treat that in terms of whether or not she's fit now to have the kids? I mean, is there something in the statute or something that you can elaborate on that?
Senator, go ahead.
Mr. Chairman, Senator Schuler, I don't think there's anything in statute. I think that's handled on a case-by-case basis through the agencies. You'll have to ask them. I'm not a lawyer, but I imagine once the parent has come out of treatment and is clean and sober and is a fit parent again, then their rights are restored and they can make those decisions as they see fit for their children.
Go ahead, Senator. Absolutely.
The other question I had was the child, when they get to make the decisions to not have the grandparents' visitation, do they have to be 16, 18? What's the situation there?
Go ahead, Senator Brightman.
Mr. Chairman, I think it would be 18, just as a wild guess based on minors, but that's a question for the department.
Senator Case.
Mr. Chairman, thank you very much. I understand those questions, but I don't think this is really about where the grandparents take in and have custody while something's wrong with the parents. I was looking at and Senator Biden, I was looking at the statute that you want to repeal. I think I remember when this came in, but 27101A, it says a grandparent may bring an original action against any person having custody of the grandparent's minor grandchild to establish reasonable visitation rights to the child. If the court finds, after a hearing, that visitation would be in the best interest of the child, and that the rights of the child's parents are not substantially impaired, the court shall grant reasonable visitation rights to the grandparent. And that there's more qualifying, but that's the basis of it. So I guess I'd like to know, and I'm anxious to hear from your constituents, how that seems reasonable to me. It sure does when you look at the words. So I'd like to hear how that didn't work, and if there's a remedy when it doesn't work. So thank you, Senator Beitman. Thank you, Mr. Chairman.
Thank you,
Senator
Mr.
Beitman,
Chairman. That's a
comments?
great segue into maybe having my constituents tell their story at this point.
Okay, sounds great. Committee, anything further for Senator Beitman? We can come back to him.
Absolutely.
We promise we will. Good morning. I'm going to ask if both of you would be willing to introduce yourselves. We have folks online this morning. We've got folks in the room, and just for the formality, we need to know who you are.
Okay.
And
Hi,
real
Mr.
close-
Chairman.
Yeah,
Is that good enough?
absolutely.
Okay.
Good job.
Hi, my name is Nikki Ward, and would you like to hear my story? Okay. So my first husband passed away, leaving me with 2 young children, and I'm going to try not to cry. And they're his parents that sued me for my children. These individuals, the grandparents, I was married for several years before he passed, and I knew his parents. We lived not real far away from each other, and so I knew them really well, and there were some things I was concerned with. And the grandfather has alcohol problems and major anger problems, and we dealt with it because, my husband at the time, that was kind of the buffer, and so it went, and then he passed away. They found out about the grandparent visitation statute, and even though I let them see the children, because I knew about it too, I Googled it wondering, okay, he's passed away. I'm nervous. And I saw that there was a grandparent visitation statute out there basically saying they can sue me. And I'm a fit parent. I don't do drugs. I don't abuse alcohol. I homeschool my children. We have a lot of fun. But there's something out there, that statute saying that they can take my kids. And they chose to do that. I lived about a half hour away from them, and I tried to schedule seeing my children on Wednesdays at my home because the grandfather was making me nervous. And then on weekends, the kids did soccer. And so I said the soccer games on Saturdays. So they came to these, and it wasn't enough for them. They wanted more. They wanted to take my children without me, because they didn't like me, to their home. And I said, well, no, you can come see the kids at my house. We have games to play. We have a whole huge backyard. And that wasn't enough. So they decided to sue me because of that statute. I didn't know they can do that. I was letting them see my children, and it was just under my consent, my control. I had a little control over it, so my kids just weren't off with them. And I thought that was fair, and they didn't like that. So they sued me. And sorry. And
You're doing great. Thank you.
okay.
Thank you for this.
And
We really
I
want to hear.
thank you. I didn't know that they could, and because they were seeing them on a regular basis, as much regular as I could, because I wanted to keep that kind of going. I mean, things weren't terrible, but they weren't really great either because I lost my husband. Things were hard. And then I met Andy, and we started dating, and they continued to sue me. And I had an attorney that was not a very good attorney, and he basically said they'll get whatever they want. you better comply. And I didn't, I was still single at the time, and I didn't know. I was very scared. I thought, well, I don't want to just give over my kids, but here's my attorney telling me, yeah, you're gonna have to. It's written right here. It's in this statute. They have a right to sue you. They have a right to take your children. And I was like, I didn't understand. So I went ahead and complied because my lawyer told me I should. And so we settled. I was out of court because I didn't want to go to court. It's just not my thing. Obviously, it's not my thing. And didn't want to go to court. So I settled, and I was not happy with it at all because it's not what I wanted. And that's how that whole thing got started. And then I married Andy, wonderful father. The kids love him. And we decided that after we got married that Andy would adopt my children as his own. And so we were one family unit, instead of two different names. I wanted us to be a family. I thought that was very important. And so he did. He legally adopted my children, and they were so excited. We have pictures. And we decided at that point, well, since now he's now a parent to these children, that we maybe would have some more ground to stand on to say, okay, let's no more of this. We need to have more control over this. And so we sent the grandparents a letter saying, okay, no more having our parental rights. Basically, at this point, I felt like I was alone, and now I'm not in this decision making. And we sent them a letter saying, okay, no more of this lawsuit. We're not gonna comply. And they got really mad, and they brought me back to court because I went against the order because I said no. I'm a fit parent, and he's a fit parent, and we said no more. We need to have better control over this, and they didn't care. Took me back to court for show cause, I think it was called, as to why I said this. Why did I go against the court order? Well, because we're fit parents, and we're a family, and we would like to have control over what our children are doing and seeing, and who they're with. I mean, and the judge in this case was totally against us. I don't know why. Like I said, we're fit parents. I don't understand what's going on. How did our rights get taken over by grandparents is beyond me. And it started with having that statute out there, able for them to do it. And then a judge that just doesn't care about our parental rights, doesn't care that we're fit parents and my kids are happy. She didn't care. She gave everything to the grandparents in the modification order to modify the order, the second one. In that order, she took all of our parental rights away. All of it. We couldn't say anything. We couldn't say yes or no to anything. And I don't know if Senator Beitman has shown you guys that. I've got copies. She took everything. They can do anything they want. And part of that bill, it's gotten to the point where in that modified order said the grandparents were allowed to come to Sheridan, that's where we live, and have 4 hours in Sheridan with the kids, without us, of course. And I go, okay, I guess we got to comply. I don't understand why we have to comply to this. We're fit parents, but we have to comply. And they decided they were going to take our kids to an Indian reservation and to go see her sister who lives there. Freaks me out. Have you guys seen the Indian reservations? They're terrible. It's scary. And Andy and I, we said, no. You guys can hang out with them in Sheridan. I mean, it should be our right to say that. Just stay in Sheridan and have fun. There's things to do here, lots to do. Don't take them to an Indian reservation where your sister lives. And they drug us back to court to clarify the order. What it in Sheridan, what did that mean? And the judge went with them and said they can do whatever they want. They can take them. They've got 4 hours with the kids. They can do whatever they want. Too bad for you. I firmly believe that If this grandparent visitation statute was not out there floating around, this wouldn't have happened to us. This has cost us a lot of money in legal fees, and a lot of headache, and a lot of sadness in our family. And the boys have been, my children, the boys have been seeing a counselor from it. They don't understand why they have to go. They don't like them. They don't want to go to their house, but according to the order, they have to go to their house every month and spend a weekend and sometimes even a week or longer. This is how it's written. And then sometimes they come to Sheridan for 4 hours without their parents around, and they're not comfortable, and they don't understand why mom and dad can't say, okay, we'll fix this. We'll make it so everybody's comfortable. We don't have that right because of that statute floating around. And these particular grandparents took advantage of that statute, I believe, honestly. They took it and they found a judge that took our parental rights away. And I would like my parental rights back. I'm a good mom. He's a wonderful, wonderful dad. So thank you.
Ms. Ward, thank you. Appreciate that, you catching us up on what helped to bring this bill here. You know, my first year here was when some of this statute was written. And I can remember the testimony, I can remember the debate on the floor. Certainly understood all of the passion on the other side of this issue. I can tell you this, your story is not what we had in mind when we put this statute in here. You know, my heart goes out to you guys. Being a grandpa myself now, having been a parent, it's heartbreaking what you've been through. So appreciate your testimony. Any questions, senators? Senator Case, and then we'll go to Senator Schuett.
Ma'am, how old are your children?
Right now they are 7 and 10.
Mm-hmm. How are they doing?
They're great.
Good.
They're learning a lot in homeschool, I'm hoping. But right now they are they're with my mother right now, the other grandparent that obviously didn't sue us for visitation. They love it going over there, and they're great kids, and they're learning so much. And my oldest, who's 10, he feels like he has absolutely no control of what's going on around him. And honestly, I think he should have a say. And he did talk to the judge. It was a private online a session with him and the judge, and she didn't care what he had to say. She just blew him off.
So, Mr.
Follow
Chairman,
up, go ahead, Senator Case.
I hear what you're saying, for sure. I'm also kind of in my mind, I'm thinking of those grandparents who lost their son, and this is their only connection to him with these children. And I can think about how tough the court is to try to balance that thing. And I hear you say that your rights have been taken away. And what I hear is that you've been forced to share, and that's not working out very well. I think the court still recognizes you as the parent and has provided for this arrangement, which doesn't seem to be working. I don't know the answer. Maybe the court we have to give more guideline to the court in terms of these grandparent interactions. Is this letter from Ms. Strassler related to your case?
Yes, that's
Okay. And in there, they mention that this counselor, Mr. Chairman, mentions the visitation schedule that the grandparents have. And if it's okay, I would just read it. It says monthly weekend visits with grandparents who live 3 hours away from the parents, as well as a week-long visit during Christmas, spring break, and the summer. So are each one of those a week? A week at Christmas, a week at?
yes, and then also there's more added on because we went against the court order, so there's more.
So, Mr. Chairman, That seems like a lot of visitation to me for grandparents. You know, and I can understand the concern of parents not controlling the home where children go, and then having overnight visits be possible, and week-long visits. So I do understand that, but I'm wondering if we're amending the wrong statute. But well, I'm more interested. I'll shut up and listen.
Thank you, Senator Case, and we can certainly come back to that. Senator Schuler?
Thank you, Mr. Chairman. Actually, I think Senator Case and I were on the same page. I was wondering how old the kids were and whether or not the judge had a chance to visit with them, and because I think that's important. I guess the only other thing that I would piggyback on is, did the judge take into account the fact that the grandparents live quite a ways away, and that this would be a hardship on probably them and you? I don't know who has to take the kids and who has to pick them up and all that, but did they take that into consideration?
Ms. Ward?
Yes, she did. So she knew everything that was going on, and she still made her ruling.
These family law situations are very, very difficult to thread needles and figure things out. Senator, is anything else for Ms. Ward? I'm going to ask all of you three, maybe, and Mr. Ward, do you have, Andy, do you have anything that you want to share this morning? You're sure welcome to testify. Appreciate you
Absolutely.
coming all the way down.
Absolutely, Mr. Chairman.
Yeah,
Would you like me to do that now?
absolutely. Yeah. Take it
I
away.
appreciate all of you changing this from Monday to today. It allowed us a chance to get down here. I am a Marine veteran, and I fought for this country in 2 conflicts overseas. I fought for the rights of our country. And my rights as a parent, now that I am a legal parent to our 2 beautiful sons, are absolutely zero. And the first order that my wife entered into, apologize, I'm a little nervous, but
No need for that.
actually had language in the order, something to the effect of if things couldn't be resolved civilly, the mother had the final say on what was to happen or not happen. In the order, or in the hearing to change circumstances, the judge actually said on record the alleged adoption. She wouldn't even honor the adoption had actually happened. That is on the record. And she stripped every single sentence out of the order with anything pertaining to parents have final say. These grandparents, in my opinion, just because you have the gene pool on the family tree that says grandparent doesn't mean you're a good person. If my neighbor, if Senator Beitman was a drug dealer or an alcoholic and I didn't want my kids to be around him, I should have the right to say that. No different than a grandparent. If they're not good people, I should have the right to say no. And right now, we don't have that right. The Supreme Court of Wyoming last year already reversed 2 of these decisions. Our case is going to the Supreme Court this year and will very likely be turned over. And I will not quit fighting for parental rights until we get them. I'm a Marine. I don't give up. And that's what Marines do, is fight for our rights. And I will do that until we get it. So I appreciate you guys' time. Thank you.
Thanks again for coming down, Mr. Ward, and thank you for your service. We're very grateful for that, and thanks for bringing this important policy discussion all the way down from the northern part of the state. Questions for Mr. Ward? Okay, I'm going to ask if you guys might thank you so much. I'm going to ask if you can step back, and we're going to take testimony on the bill from others, and Senator Beitman will reserve the right to come back to you in a little bit, okay? Okay. Let's go to further testimony on Senate File 161, Parental Rights Repealing Conflicting Statute. Please come forward. Good morning, welcome. Please state your name for the record for us.
Good morning, Mr. Chairman. My name is Beth Lance. I'm here today on behalf of the Wyoming Trial Lawyers Association. I quite appreciate certainly the position of the case that we just heard. I am also a family attorney here in Cheyenne, and I represent from time to time both parents and grandparents in these kinds of cases. I think the most important piece of information I have to provide this committee this morning was just briefly alluded to here by Mr. Ward, and that is that our Wyoming Supreme Court greatly narrowed grandparents' visitation rights in this state just last year. So there is a Wyoming Supreme Court case, Ailport v. Ailport, and that is spelled AILPORT. And that came out in February or March, I believe, of 2022. And if you'll so indulge me, I'm going to read just a conclusion paragraph from that case so that you all can hear what the court's current legal position is in Wyoming on grandparents' rights. Our court stated, parents have a fundamental due process right to guide the upbringing of their children, including determining the level of contact with their grandparents. To satisfy strict scrutiny, which is a high level of scrutiny that the court applies when anything deals with parental rights. They stated Wyoming Statute 27101 must be interpreted to protect parents' fundamental right by requiring grandparents to prove parents are unfit to make visitation decisions for their children, or the parents' visitation decisions are or will be harmful to the children. Only after the grandparents make that threshold showing by clear and convincing evidence, which is also a much higher standard to prove to the court than our normal civil cases, just to clarify. Only then may the district court determine what visitation is in the best interests of the children. In this case, the court found the grandparents did not meet their burden of establishing that the parents were unfit or that the parents had made decisions harmful to the children. And therefore, the Supreme Court affirmed the district court's decision, which was to not order grandparents' visitation in that particular case. So while I understand that certainly we could probably have all kinds of parents come in here that in the past had grandparents' visitation cases ordered against them that were not satisfactory to them, that they felt were infringing on their parental rights. As of right now, the case law and the Supreme Court has vastly narrowed that, and it doesn't require a changing of the current statute. The law now that will be applied has to be this case law by our district courts. And so, in fact, just in my own practice, I had an open grandparents visitation case when this case came out, and we dismissed it because this case clearly would have made that case not viable, and we would have not won under the new law. So it's quite important too, I think, that courts do try really hard always, and even under our past law, to balance the fundamental rights of the parents in these cases, particularly in the extraordinary case that was just mentioned, which is when one parent is deceased. And so those grandparents are just trying to maintain a connection with those grandchildren, which unfortunately often becomes objected to by the surviving parent. So that is a fact scenario I have unfortunately heard before. There was some alluding to just to be clear, obviously guardianship is different than grandparents' visitation. There are times in which grandparents may have guardianship in situations where the parents may have drug and alcohol problems. Where I think it's important to leave the door open, at least for potential courts to order grandparent visitation, would be in those kinds of cases, because sometimes those grandparents have raised those kids for years even, and they have now been returned to a recovered or recovering parent. And it's important often, and in those children's best interests, to have grandparent visitation to maintain that relationship, which may be a very close relationship, since those grandparents may have stepped into the parental role for a period of time. And so this proposed bill would make none of that possible. It would completely repeal grandparents' visitation. The courts would no longer be able to even contemplate these cases, and would not be able to even look at any extraordinary fact scenarios in which it may be appropriate to order grandparents' visitation. So for that reason, the trial lawyers are opposed to this bill. And I would stand for questions.
Ms. Lant, very helpful. Thank you. Senator Schuler.
Thank you, Mr. Chairman. I guess my question goes back to what you talked about in the courts, where they have to have a clear and convincing evidence to prove fitness. Is this a psychological evaluation, physical? I mean, is it dependent on whether or not they've had issues with criminal acts? And then also, I guess, in a follow-up to that, is there any issue where grandparents are required to prove their fitness as well?
Ms. Lance, go ahead.
Mr. Chairman, Senator Schuler, these cases are all different. They all look different. They're so fact-driven, just on the particular people involved and their specific circumstances. But certainly in these cases, I have seen expert witnesses who have given evaluations or who have testified to people's character. All of that would be potentially brought before the court. So if you had evidence, for example, that a grandparent had a drug or alcohol problem and therefore shouldn't have visitation, certainly as the attorney, you would be looking to bring all of that information and evidence in front of that judge. So the judge had all of the information before making these kinds of decisions.
Further questions for us? Let's go ahead, Senator Case.
I kind of remember now why I never wanted to be back on Judiciary after 29 years. I think this is starting back then. So if I understand the state of the law now, it just sounds so, if I look at the words in the statute, it sounds collaborative to me. You know, the court will grant visitation if it doesn't unduly interfere with the child's rights and the parent's rights. I mean, that's sort of collaborative. And then if I understand, Ms. Lance, your characterization of the Supreme Court's ruling, it sort of says like, you only get rights if you can, prove unfitness, basically. And it's only rights to visitation. So what good does it do to have a weekend a month when the parent, and is that supposed to fill in the fitness of a parent that's unfit for? I mean, it seems like it was a nuclear bomb, and it wasn't collaborative. And I'm sure the circumstances in that case warranted it, but isn't there any room in here for, more leniency on both sides? I know that you know what I'm trying to say.
Ms. Lance, go ahead. This goes in the direction I was going to go, so I like that question.
Mr. Chairman, Senator Case, a lot of the analysis in our this recent Wyoming Supreme Court ruling is based off of United States Supreme Court case law. And so this is the direction that the nation really has taken in these cases. And so really our state Supreme Court is following what our federal courts are the direction that they are going. And again, it's just a balance of those fundamental parental rights with the grandparents and the best interests of the children. Just to clarify, what you are proving is that the parents are unfit to make visitation decisions. Not that they're unfit parents, but that they are unfit to make the visitation decision for some reason, that they are not thinking clearly or logically in regards to whether visits with grandparents are good or bad for their children.
Go ahead, Senator. Yeah. Mhm.
Thank you very much for that, because that sort of, that helps a lot. So, and that could be because of animosity between the parties, competition. I mean, lots of reasons. So that's a little bit narrower than I was alluding to before, and I do appreciate that. I'm going to think about that some more. Thank you.
So, Ms. Lance, that leads me to a couple of questions I had. Knowing that you were going to testify, I bet that you reread the statute a couple of times. In your profession, probably. And by the way, God bless you for doing what you do. I'm glad we have those who can deal in family law. It's a really, really big lift. My question regarding the statute is it adequate? And given the circumstance that we've heard about this morning, so two questions. Is that statute adequate? Is there anything that you would recommend to us that we can do with that, given the story we heard? And then the second piece of it is, what other remedy do folks like these have than going all the way through the Supreme Court and having to pay professionals like you to help them all the way up the ladder? That doesn't quite seem right either. So can you hit on those 2 points for me, please? Thank you.
Mr. Chairman, first I would say, as of right now, the law is what the Wyoming Supreme Court has said it is in interpreting 27101. I don't know that I would say that there is anything necessary to be changed. The Wyoming Supreme Court has already explained how that statute will be interpreted by the courts. If this committee or body was so inclined, I would potentially have to spend time with it, but there may be some language changes that would just align with the new language that has been offered in Alport by the Supreme Court. But otherwise, no, I wouldn't say that I had any suggested changes to the current grandparent visitation laws. And I apologize, what was your second question?
Well, the second one revolves around really a difficult trail that these folks have been through up there in the courts in Sheridan County. It sure doesn't feel like the judge in that part of the world interpreted things the way that we've heard that the Supreme Court has.
Let's write him a letter.
So my question to you is, what guidance would you give in a situation like this? I guess the only thing we can do when we run into a situation like that is climb all the way up the ladder and go to the Supreme Court?
Mr. Chairman, I think unfortunately, yes. I think what we've heard today is this family's case is pending in the middle of the Supreme Court essentially changing its interpretation of this statute. And so they kind of got stuck where they got a decision that was likely pre the Supreme Court making this decision. And now they have to go to the Supreme Court to get the application of the new holding. And so it's an unfortunate situation. I think it's quite rare. I would say for the most part, grandparents visit their grandchildren without court intervention. That is not typical. It's quite atypical. And even to the extent that someone may bring a case for visitation, they are most often settled outside of court. Them being truly litigated, as occurred here, is not a frequent type of case that we see.
Okay. Thank you for that. Any further questions of Ms. Lamb? Thank you. We may come back to you with a question later. Appreciate you being here this morning.
Thank you.
Further testimony? Oh, Senator Case, absolutely.
And I'm sorry, I should have done it so for all those orders that have been entered that are on the books, that people would now be able to go back to court and argue that those orders are unfair. And that wouldn't require going to the Supreme Court. They'd have a new proceeding in whatever court they have access to. Would that be fair?
Ms. Lance?
Mr. Chairman, Senator Case, again, it's on quite a case-by-case basis, but certainly as an attorney, if someone had an existing order that was not satisfactory, I would definitely be looking to see whether the Supreme Court's new decision would potentially change that.
Go ahead, Senator Case.
So if you were to pursue that as a parent, you were to pursue reopening an existing order, would you be required to go back to the court that issued the order?
Mr. Chairman, yes.
Okay,
And typically the same judge unless it's just a new judge.
so there's the rub a little bit. So,
A little bit.
yes.
Yeah, just a little bit.
And so can I do one more on this?
Absolutely, Senator Case, go ahead.
All right, you have an old order from a parent goes in to pursue changing the order. They can't get to the Supreme Court without going back to the first court and asking for the order to be changed and then having it denied, I guess, or be unsatisfactory, and then appealing that order. That's the only way they could get relief. Is that what I'm understanding?
Mr.
Ms.
Chairman,
Lance.
Senator Case, that is correct. Yes, yes. The Supreme Court will only review the district court's decisions.
And it can't be an old decision. It has to be.
That's
It
correct.
has to be ripe.
That's correct. You have to have a new order.
Uh-huh.
And from the time you receive an appealable order, you have 30 days.
That's what I'm getting at. Thank you, Ms. Lance. Thank you, Ms. Chairman.
Thank you.
Thank you,
Ms.
Mr.
Lance.
Chairman.
Really appreciate it. Further testimony on Senate File 161. Good morning, sir. Welcome.
How do you do, sir? Fine, thank you.
Are you Mr. Murphy? Good morning.
Yes, I am. Good
Please
morning, Mr.
introduce
Chairman.
yourself for the record and welcome.
My name is Sean Murphy. I am born and raised in Casper, and I moved back to Cheyenne a year and a half ago after living in Denver for 10 years. And I'm here today representing myself as a dad and to just share my story and, in a way, my expertise as a parent that has been through, many of these issues that we're talking about today. I'm here really because I went through a 4.5-year custody battle in Denver. My son, Atlas, he has a terminal brain disease, and there was a difference of opinion on medical procedures that we would do. His mother and I disagreed, and it led to a divorce. And then there was a 4.5-year custody battle over basically fundamental rights, what we would decide to do for Atlas. A couple of key medical decisions. One was around vaccines, and another one was around using CBD. He has a terminal brain disease. It's called Alexander disease. It's an incredibly challenging situation. In the first year and a half of this, we had over $500,000 in divorce legal fees between the two parties. I was totally out of money, fighting for what I believed was best, and represented myself pro se. And I was able to do that because my dad is an attorney in Casper, a grandparent in this case.
I know him. He's a
Yep.
friend of mine.
Yep. And the only way I was able to be pro se was because I had his help. But in doing this, I basically became a divorce attorney. Like 3 years of representing myself. I wrote all the briefs. We've had 16 hearings. I cannot really begin to explain unless somebody looks at our court record in Denver how incredible this case has been. But in doing this, I've really become an expert on parenting rights and where the rubber meets the road. And this bill in particular, if it were to pass, it would be the situation that if if, let's say I passed away, and the custodial parent, my son's mother, had custody of our child, like my dad or my parents, their only remedy to ever see my child would be to use the existing statute. It's a good statute in these extreme cases when a parent dies, that grandparents have the ability to see their grandchild. It's really good in that way. I understand this is a difficult situation here, but what I heard from this testimony is these grandparents wanted to see their grandchild, and it sounded like these parents were not allowing that. And it's a very rare situation, but I can tell you, if I were to get hit by a truck, which just isn't likely here in Cass or in Cheyenne with our traffic, this statute is the only way my parents would ever see my son again. It's just the nature of divorce, unfortunately, that there is often such conflict that one side, the surviving parent, they try to block the other side. And there's always reasons, and there's a lot of rhetoric and a lot of emotion. And it's very sad and very wrongful. So I'm here today most immediately to say, I think we're looking at this the wrong way. I think we should be talking about doing an interim topic on shared parenting rights. This is a big issue, and it's something we should look at from that perspective, because I think we messed this up last year with the fundamental parenting rights. We said we have this fundamental parenting rights bill that we passed in 2017, but it's not being applied by the courts. That was under, I think it was HB 83 last year, Representative Stith's bill, where it was saying fundamental parenting rights were not being applied by the courts. And that's the real issue. But the issue that precedes that is shared parenting, because when parenting rights are taken away, then all the parent can do is say, well, it's a fundamental rights issue, to try to claw back their parenting rights. But if we address the origin of the issue, which is the nature of shared parenting, we're able to set things right from the beginning on equal playing field without, and this is the term that I wrote down here, without the divorce industrial complex mobilizing. And you see this a lot in court cases, that the groups that ultimately do the best when there's a lot of conflict and fighting is the attorneys. So when we come to these committee hearings, we hear from the trial lawyers and the litigators and the family law attorneys. They don't want to change. They don't want reform, because they're making a lot of good money fighting these cases. And then the Supreme Court will say, well, we have many of our cases, they end in shared parenting. Well, that's only after you get to the Supreme Court. You know, my dad has won dozens of cases in the Supreme Court, and he's like, that's a long journey to get to the Supreme Court. So what we want to do is try to address it from the beginning. And what I've shared here with you today is the 6 elements of good shared equal parenting. And this is what would really go into what I would call a fair and balanced and reasonable shared parenting approach. And it's a complicated topic. It can't be really resolved in one hearing. We've had a couple of bills. There was this one this year, House Bill 78, and immediately you see the issue between the divorce industrial complex and parents like me that are just trying to hang on, through all of the fighting. So it's really a miracle that I'm still here after 4.5 years. I've put everything into fighting for my son. He's very sick. I was at Children's Hospital yesterday. Brain diseases are brutal. Like he can't use his bowels at all, so it shuts that down. So I'm still in the meat of this. I moved here because for business and the Bitcoin industry, and I've really had an expertise on the electrical side of what's going on in that. But I'm really just here today as a parent because I know this issue so well. I've lived it, and I've seen the angles. I've seen the games that the attorneys play, and also the games that parents play against each other. And I think we can do it right in Wyoming, but it's going to take a deeper look, which I think is we could call it parenting rights or shared parenting, could roll in fundamental rights and grandparenting rights to that if the committees thought that was the best way to look at it. But this bill, I'm against this, because if I were to die again, it would be the only option that my grandparents would have to ever see my son again. And I'm an extreme case that, he might only have 5 or 6 years left. My dad would absolutely use this to try to see his grandson again before he dies. So that's why this is here. It's an extreme case kind of situation, but I don't think we should be going about this and creating more unintended consequences. with passing this bill we're talking about today. Thank you for letting me share that. It is a very personal and in ways emotional topic, parenting and children and grandparenting. It's hard to, it's sometimes just hard to even form all the right thoughts around this because they're such personal topics.
Thank you for taking the time this morning. It's an
Thank you, Mr.
important
Chairman.
issue. Yeah, we have not had time to read your notes. I appreciate you bringing them, and I look forward to perusing those as we go along. But questions for Mr. Murphy? Anything? Our hearts go out to you with your situation with your son, and we'll throw some prayers your direction too.
Thank you, Mr. Chairman.
Thank you.
Appreciate that.
Murphy. Appreciate it. Further testimony on Senate File 161.
Mr. Chairman.
Good morning.
Good morning, Mr. Chairman. Bill Winnie, Sublette County. I oppose the bill. I'd also like to turn the argument around. And by what I mean by that is, in my observation, children have a real need to figure out where they came from. Who are their parents? Who are their grandparents? Other people they are exposed to in school, coaches, and so on. And they kind of integrate all that into the person they're going to become. They're thinking about it. Here at the end of the month, my grandson, who lives down in near North Platte, Nebraska, is going to be awarded an Eagle Scout badge. He's going to be pinned with a badge that was awarded to my father in 1925, me in 1965, and his father and brothers starting in the 90s. So there we are, fourth generation Eagle Scout. Who is he? What's he going to be? What's he going to become? So you get the idea. Kids need to sort that out. They need to see their grandparents as much as the grandparents need to see them. We see a similar thing in military organizations where people in their 18, 19, 20 years old become something much greater in their 30s. You know, you go back to the Battle of Lady Gulf. Who told that CO of a tin can to turn his ship toward battleships, but it carried the day? Who they're going to become is important. They need to see their grandparents as much as the grandparents need to see them. Subject to your questions, thank you.
Thank you, Mr. Winnie. Appreciate it. Any questions? Okay, thank you very much. Further testimony on Senate File 161. Anyone else like to testify on 161? Judy, is there anyone online this morning who would like to testify on this bill? Okay, and Judy, I did not hear the name you gave me, but
I'm sorry, I forgot to turn on the speaker. Jan Loftus and Casey Craven.
if you would let
They're both me.
Jan in, that would be great. We'll start with her and then
I'm not sure what happened to Jan. Casey is available. We'll try Jan one more time. If she doesn't have her hand.
please speak into your microphone for us, Judy. When you
We
do,
have-
yeah.
I'm sorry.
I-
We have Casey Craven if she wants to turn on her audio and video.
Okay, that looks like maybe
That's her.
maybe that's her.
Members
Ms.
of the
Craven,
committee.
good morning.
Good
Go
morning,
ahead.
Mr. Chair. Can you hear me okay?
We can.
Wonderful. My name is Cassie Craven. I'm testifying today personally as an attorney. I too am a member of the Wyoming Trial Lawyers Association. However, I stand in support of this bill today. I'd like to first reflect on a couple of previous bills that this body has passed in 2019. The first of those was House Bill 157. That was in 2019, and it's now statute 14-2-310. Another bill is House Bill 155, also passed in 2019, now codified in 3-3-1107. To address Senator Murphy's previous concerns, these bills were very carefully crafted. And I worked heavily on that effort so that we could allow for parents to have guardianship visitation that did not infringe upon parental rights. This was an important effort because we recognized that there was significant amounts of families that were impacted by drugs, and that parents oftentimes would come back on the scene after months of leaving their children with these grandparents. So in order to have for visitation rights, we needed to carefully engage in that balancing act and allow for the courts to have the guidance that they needed to craft these careful agreements. The verbiage of those statutes recognized that the fitness of a parent was presumed and that this was a statutory right. It's very important, I think, that we support this bill today because there's been a lot of confusion in the Supreme Court. As testified to already by Ms. Lance, Ailport versus Ailport really had a hard time weighing these factors. And I'd like to read one paragraph from that case as well. The current version of 20-7-101A does not include the specific procedural safeguards mentioned in Michael, incorporated a presumption that parental decisions are in the child's best interest and according with tribal, or required grandparents to show the parents are unfit or the child is or will be harmed by lack of visitation as required to establish a compelling state interest under strict scrutiny review. In essence, I would assert to this body this morning that we've kind of given the Supreme Court a mess to deal with. I think the best cause of action would be to proceed on this bill and support it, revoke the previous statute, and take this issue up for a further interim study, essentially to start from scratch. I would ask that this body also consider reading that case in its entirety to really weigh all of that out. We're citing Maryland, Kentucky, all of these other states to try to figure out what this law means. It's also important to note that this law, as it's written right now, supports a system where only the people with the most amount of money to fight the cases make it to the Supreme Court. Most parents raising young children cannot afford that effort. There are a variety of families that have been impacted, and I've seen that firsthand. They're unable to fight on under these conditions to assert their fundamental constitutional rights both to parent and of familial association. I'd also add that this current statute as it stands has not been challenged on those specific grounds, and if it were, I think that there's a good chance it would be overturned. I think this is an important issue that impacts families, but it's worthwhile to give it some further study under new parameters. And in the meantime, get rid of this law that the Wyoming Supreme Court is having such a hard time dealing with. Imagine a scenario in the last two cases cited by Ms. Lance where these make it all the way up to the Supreme Court and the Supreme Court disagrees. The previous speakers have pointed out that these last years, they cost tens of thousands of dollars, and we can't unwind the hands of time toward the best interest of children. These kids' lives have been impacted for years. And by the time it makes it to the Supreme Court and they don't agree, where does that leave these families? I think the most constitutional thing to do is to support this bill and further take this issue up for interim study. Thank you, and I'd stand for any questions.
Questions for Ms. Craven? Ms. Craven, just a real quick question. I'm just trying to get in my mind what you have suggested. I've heard several times this morning that we ought to take a look at this during the interim. I think that's probably good counsel. But I am a little bit surprised that we would leave a hole in our statutes. That's what that would do. If we pass this bill, we take the grandparents out of the picture for a while, do we not?
Mr. Chairman, I think the most appropriate constitutional method would be to pass this bill today. And essentially that puts the brakes on. Then we could allow for an interim study to decide if we want to have this type of grandparents visitation in the law. I would argue that it doesn't leave a void. There are already two mechanisms. For example, the statutes that I cited, which allow for guardianship, and in cases of safety, a tiered arrangement where parental rights could be restored. And there are also DFS cases, which place primary preferential placement with blood family. What we're deciding as a body, what you're deciding rather as a body, is whether or not to allow for these very expensive, lengthy civil custody. Not every state has that available. Wyoming needs to make a policy decision. So the question, as I see it, is should we leave a law on the books today, which has been pointed out to be flawed and problematic by our Supreme Court, while forcing families and children to hang in the balance and spend tens of thousands of dollars, or maybe not even get their day in court at all because they can't afford it, and causing further damage? In my opinion, the place of the law should not be to cause further harm. It should be to allow for further good. So I think the most prudent effort to address your question directly, Mr. Chairman, would be to pass Senator Reitman's bill today, and then take this important issue up for interim study, reading the case that Ms. Lance cited, and seeing where our statutory framework was derelict in articulating any factors or guidance to the court that can be applied in a consistent manner by the district court.
Thank you. Any other questions? Thank you, Ms. Craven, for being here this morning. Appreciate it. Further testimony on Senate File 161. Judy, do we still have a second person who would like to testify?
Yes, we do. I'll just bring her in. Jan Loftus.
Okay, if you please join us, turn on your video and your audio. And we would welcome your testimony this morning.
Ms. Loftus, you need to turn on your audio and video, please.
Good morning, Mr. Chairman. Can you hear me?
We can, Ms. Loftus. If you have video, please turn it on.
Okay. There we go.
Okay, good morning. Welcome.
Thank you. Appreciate your time. I am Jan Loftus, and for 9 years in the recent past, I was the Wyoming coordinator for parentalrights.org. No longer am. I'm here today as a grandmother of two, of course, adorable grandchildren. I was often asked, what about children's rights? And the answer to that is, once a person thinks about it for a while, is children do, of course, have rights, but those rights are protected by their parents when they're minors, is the way that it has always been. Biblical times on. Children have rights, but the parents are the protectors of their rights. Parental rights have been protected by the U.S. Supreme Court for 100 years as a fundamental right. The court has repeatedly held that parents have a fundamental right to the care, the custody, and control of their children. But parents continue to confront obstacles in exercising these rights. The bar to interfere with a fundamental right is the highest bar of all. That to interfere, the state has to have a compelling interest. And when it does step in, it has to be with the least restrictive means. Part of care, custody, and control is who our children associate with. Third parties who wish to overrule the wishes of parents must be required to prove parental unfitness. There was a case in Arkansas Supreme Court, Linder v. Linder. The court wrote, "Are we to say parent is fit in all other areas of care, custody, and control, but not in association?" It appears the trial court found the mother to be a fit parent for all purposes save one. The question becomes whether unfitness solely to decide visitation is a compelling interest on the parent of the state that warrants intrusion on the parent's fundamental parenting right. The Arkansas Supreme Court said, "We conclude it is not." There were 2 Wyoming Supreme Court cases in 2022 dealing with this issue, grandparents versus parents. I'm a grandmother, and I know that grandparents and aunts and uncles and old siblings that are adults are very important. Yet parents have the fundamental right, not grandparents. The two cases both held for the parents. One was overturning the lower court and one was upholding the lower court, but they used different rationale. Alport v. Alport, you already heard mentioned, upheld the lower court. Bowman v. Study overturned the lower court. This bill will provide clarity to the lower courts. I support this bill. I didn't say that at the outset. In Bowman, the parents repeatedly drew the court's attention to their concern with applying Wyoming Statute 27101 in a manner which did not protect their fundamental rights. Wyoming Supreme Court concludes in Bowman, the district court did not adequately protect parents' fundamental constitutional right to rear their children as they see fit when it ordered grandparent visitation. In Alport, the other case, Wyoming Supreme Court wrote the plain language of Wyoming Statute 27101 contemplates state interference with parents' fundamental right to rear their children. Therefore, the statute will satisfy due process only if it passes strict scrutiny. To reiterate, the court went on to say, a statute impacting a fundamental right is constitutional under strict scrutiny only if it is necessary to achieve a compelling state interest. And the method of protecting the state's interest is the least intrusive necessary to accomplish the goal. Later, the court wrote, I think this is critical, we must search for legislative intent that is consistent with constitutional principles. The court said they have to search for legislative intent consistent with the Constitution. Even though the Wyoming Supreme Court came to the same conclusion as the district court in Alport, the Wyoming Supreme Court used a different analysis to get to that result. They focused on the fundamental constitutional right of parents to raise their children as the parents saw fit. The Wyoming Supreme Court held that the way judges were interpreting the grandparent rights statute failed to adequately account for the parents' constitutional rights. So in both of these grandparent visitation cases in 2022 at the Wyoming Supreme Court, there was confusion in the lower court. The grandparent visitation statute does not meet the high bar to interfere with a fundamental right, as shown by these Wyoming Supreme Court decisions. Legislature should not leave this confusion to stand. Again, the Wyoming Supreme Court said in Alport, the plain language of Wyoming Statute 27101 contemplates state interference with parents' fundamental right to rear their children. I just wanted to reiterate what the former speaker said regarding the guardianship statute that she gave you. And I was around when I was still in that role of parental rights when that passed. And that gave grandparents standing. Grandparents have standing when there's issues of drugs and alcohol, any questions of abuse or neglect. And that's all I had to say today. Thank you for your time.
Ms. Loftus, thank you. We appreciate your time. Any questions, Ms. Loftus? Thank you very much. Appreciate it. Is there anyone further online this morning, Judy, who would like to testify?
No, there's no one else.
Okay. Committee, I'm going to close testimony on this bill, other than to return to the sponsor of the bill to maybe bring us home to discussion at least. Senator? Thank you for initiating this policy discussion this morning.
I don't envy you on Judiciary. I remember my days on Judiciary, and you guys have to make a lot of tough calls.
Yeah.
But Mr. Chairman, members of the committee, we heard great testimony today. And this clearly shows you why I brought this bill. We do have conflicting statutes, and they need to be remedied. The parental rights statute is supported by the U.S. Supreme Court and the state Supreme Court. The grandparents visitation statute is at odds with both of those. Needs to be repealed. And I would point out, when there's contention between a child's parents and grandparents, who should decide? Right now, it's the judges and the courts, and it's a very expensive process. It's a heartbreaking process for the families that have to go through this. Ultimately, the whole idea of parental rights being a fundamental right, especially with association, who you want your kids to be with, that's your right. That's my right as a dad. And when judges and courts interfere with that, we have big problems. And I think this bill is very much needed. I think we do need to repeal that grandparent visitation statute. I think it's outlived its purpose, and it's been misinterpreted in the courts, and it's causing grave harm to our constituents. Repealing it allows clarity to the courts. The findings in the bill provide the legislative intent that the courts have been seeking and guidance. And again, grandparents are key to raising children, but they're not the parents, Mr. Chairman. The parents have the ultimate say. And with that, I'll stand for any questions.
Thank you, Senator. Anything else for our fellow senator? Okay, thank you very much.
Thank you, committee.
Committee, what's your pleasure on this bill?
Bill?
Moved by Senator Schuler. Discussion. Senator Schuler.
Thank you, Mr. Chairman. Yeah, this is a tough situation. I see both sides of it as a grandparent. Obviously, I was a parent also, and I think my issue, is exactly what was presented in the bill. I don't think the courts have been consistently applying some of these statutes, and I think the parents' constitutional rights, to me, that trumps everything. And even though I would hate to be in a situation with any of my kids, if there was a situation here, I think that the courts having to prove that someone is fit, a parent or a grandparent, it just doesn't sound to me like it's been consistent. And I don't know that there's been clear and convincing evidence from I looked at a few cases too, court cases as well. And so it gave me pause, even though I understand the issues with grandparents having the opportunity to visit. I think Mr. Murphy brought up some good points with the shared parenting. Really what we want to do is protect the child's best interests always, but I just still think that rests in the hands of the parents. Thank you.
Senator Cooper.
Thank you, Mr. Chairman. I think we've definitely identified a problem here. That's pretty easy to say. But what we haven't identified is the solution to the problem. And that's what bothers me most. I think that we probably need to do some work on the statute to fix it, but simply repealing it doesn't fix it. I think this is a clear case for an ongoing interim study and really a good solid solution to the issue. I feel deeply for the parents involved, but if the situation was a little bit different, I would feel just as deeply for the grandparents involved. So every case is going to be individual, and I don't think simply repealing the statute is the correct answer. It's a possibility that it is. Maybe we'll get to that point. But I think we really need to look at finding a real solution rather than just creating another hole in the statutes. Thank you.
Further discussion? Any further discussion? Committee, I agree with both my friends here.
You vote with your friends, right?
Yeah, this is really a tough one. Committee, I think it boils down to this from a policy standpoint. It is how to fix uh, comes about. And I think we can certainly repeal this statute. We can send this bill on up and see how it goes through the process. It's got a long ways to go. We know that. I think there's 27 hurdles that a bill has to clear in order to become law in Wyoming. And that final one is you finally have to get the governor's signature. And that's not always a given. So I'm kind of inclined to move this forward simply because I think it has called into question and into relief a problem that we've got. And I think that alone can launch us into either way, whether this bill passes or not, Senator. I think we've got work to do. I think we probably do need to take this up during an interim and rely on our professionals. I'm looking at the back. Thank goodness they're here and to help us walk through how we can do this thing a little better. So the question is, do we take a statute out of the books and just hope we get that work done? Or do we leave the statute knowing that we've got to get some work done? That's really what it boils down to. I wish it was a world where we had good people who were good parents and we had good people who were good grandparents. And if all of that took place, then we would never have to have these struggles, right? Your story is heartbreaking, you guys, and really grateful again to you guys for bringing this down here. Just so you know, whether this bill passes here today and goes upstairs, and whether it passes the Senate, and whether, you know what? You don't always have to pass a bill to have some major impact. And you've had some major impact today. I just want you to know that. I've had the fortune to work in the world of domestic violence a little bit the past 5 years. We've passed some very difficult bills, and a couple of times they didn't pass, and we had to go to an interim, and we had to work and work and work to find the right place. So please know that you've had a great impact today. Okay, so Senator Case.
There's one.
Sorry.
I gotta let her do it. Mr. Chairman, I think when we talked to Ms. Lance, I understood what the consequences of letting the Wyoming Supreme Court decision play out, and it doesn't affect existing orders. People would have to return to court. But if we delete the law, remove the statute that existing orders were based on, that doesn't give automatic relief to people either, Mr. Chairman. They'd still have to go back to the court for a modification of the order. So I'm not seeing a lot of difference. What I do see is that in the case that we leave the statute in the books, there's a tiny crack that could give grandparents in new cases something. I don't even know what they get. But my point I'm trying to make here is that in either case, remove the statute, don't remove the statute, doesn't fix all those orders, and all will go forward in a new journey. One with guidance by the Supreme Court, and one without any guidance at all, with no rights at all. And so I'm going to leave the statute in if it's my choice.
Senator Furphy, anything?
Thank you, Mr. Chairman. Yeah, what a tough issue. And I've seen a lot of these cases where it really is a tough issue. I've seen it in my own family. So I'm going to vote against this bill, and we've got to fix this situation. But to repeal our current statutes doesn't make sense to me at this point until it works through the system, as we're pointing out. I'm glad the Supreme Court made that decision, and it sounds like that was the appropriate decision now, but it's just got to work through the process. So that's why I'll be a no vote at this point, Mr. Chairman.
Thank you, Senator. Anything further, committee? Okay, let's take roll on Senate File 161.
Senator Case,
No.
Senator Cooper,
No.
Senator Furphy,
No.
Senator Schuler,
Aye.
Chairman Landon.
Aye.
Mr. Chairman, there are three noes and 2 ayes on Senate File 161.
Okay, thank you. So Senate File 161 has not passed the Senate committee this morning. Senator Cooper.
Mr. Chairman, I think this is a topic that absolutely must be in the interim. This is not, we've definitely identified a problem. I got some deep feelings for the folks that were here, but we didn't come forward with a solution. So we have to go find a solution to the problem. I want these folks to know that we're not quitting them. We're just looking for the right answer. And just simply repealing it and leaving the grandparents out of it is not the right answer, I don't believe. But the answer's out there. We just have to go find it. And I thank them for bringing this really to a higher level of conversation.
You know, I agree with the vice chairman of the committee. You can rest assured, we're going to go to work on this. And I say again, oftentimes in these rooms, it's all of you who make those difficult trips and come all the way down here and think of the help that you're going to give to so many people just because of the impetus to reach out to Senator Beitman, who takes on the heavy lift and brings it here. And now we're going to go to work on something. Sometimes it just takes a little bit longer. I hope you guys understand that. And we're going to lean into the blocking sled and push it down the field. I've got a lot of faith in this committee and those that we get to work with. Let's try to find a better place so that future couples don't have to go through what you guys have. Good luck with everything back home, by the way. I hope that maybe some white caps can come off the water someday and it'll smooth out and things will get a little better. Thank you. Senator Beitman, look forward to working with you as we go forward on this. Thanks for all your efforts. Okay. Committee, we will take up some of those House bills on Friday.